repealed and which have been repealed, lawyers doing election cases and cases of a political nature have had the miserable ordeal of deciphering pages and pages of legislation. And then, of course, one had to find them in the first place. I recall distinctly when I was arguing the case in 2019 in relation to the then House registration process commenced by Chairman of the Elections Commission at that time, James Patterson, the Chief Justice of our country, the Honorable Madam Justice Roxanne George, expressed great disquiet at the state that the law was in, because it was so difficult to assemble the various pieces of legislation and then to try to understand them in a coherent and chronological way. Half of them were overtaken by events because they were passed to meet peculiar events that would have been contemplated or expected to take place or to feature at a particular election time or a particular elections. And when that elections passed, that eventuality no longer existed, but that provision or those provisions remained on the statute book, creating unnecessary ammunition for lawyers who want to advance disingenuous arguments, because the law is there and they use that to make clear positions ambiguous by injecting these different and varying and various pieces of legislation. What this exercise enabled us to do, Mr. Speaker, was to examine all this gamut of loose pieces of paper all over the landscape, to examine them scrupulously, dissect from them the irrelevant provisions, those that may have been overtaken by events, put aside those provisions that have been repealed, and to consolidate or revise, as is a technical term, all those various provisions. For example, the Election Laws Amendment Act of 2000 had about 30-something or more provisions. We had to migrate them back to their respective homes, either in the, where appropriate, either in the ROPA or in the National Registration Act. So, Mr. Speaker, even without the amendments, this exercise has been great for our law revision process, in that it has now, for the first time after approximately 3 decades, assembled all of our election laws and registration laws and related laws to those two processes. We are now putting them in their respective abode so they can be easily and conveniently accessed. Even if we have accomplished nothing more than that, I believe, sir, that we have accomplished a great lot. But these amendments go much further than that. Mr. Speaker, the bill that is before us is 63 pages in length, and the amendments that are contained therein are wide-ranging, and they cover from the beginning to the end almost of the ROPA. It is therefore physically impossible for one to go through clause by clause in this bill. One will only have to deal with the conspicuous and salient aspects of the reforms that are being proposed. So, Mr. Speaker, the first component of the bill deals with the various sections of the Election Laws Amendment Act, and to reside them at convenient places within the ROPA. So you have a series of provisions here that we are now inserting into ROPA as they are relevant to ROPA, which were found or which are in the 2000 ELA, Election Laws Amendment Act. And we have done similarly for the National Registration Act. And they are all there, the establishment of the permanent secretariat, and these are all in the laws already. It is just to situate them appropriately. The clarifying of the commission powers over the commissioner, and importantly, Mr. Speaker, one of the main policies, and perhaps I should speak to the main policies of this bill. Let me digress a little to speak about the main policies of the bill. Mr. Speaker, ROPA is nearly 100 years old, and by sheer passage of time, would have required a review in any event. However, elections 2020 brought to light the way that the legislation in its current form can be subject to abuse. Mind you, this is the very legislation that governed all the elections, including 2015, which the joint opposition won and formed the government. It presented no problems for the returning officers working in that electoral machinery. It presented no problems for the very chief elections officer who administered the 2020 elections. Both of those categories of officials and all others seem to have understood their functions quite well and performed them quite creditably. Come 2020, March the 2nd, election day was well. President Granger, speaking on behalf of the government, lauded the activities of voting day. And so did all the political parties contesting the elections. So did all the major international observer agencies and local observer agencies observing D-Day activity, E-Day activity, or D-Day, whichever wish. E-Day, I believe. It was when the tabulation of Region 4 began, then the mad orchestra began to play. 9 other regions tabulated their results and transmitted their statements of poll and the consequential legal documents to the center under the legislation without any significant complaint or difficulties. It was when the tabulation of Region 4 began that we saw a different story unfolding. And it gave us, and it gave the world, an opportunity to see how discretion can be abused, how discretion can be manipulated, how irrelevant considerations can contaminate the exercise of discretion, how ill motive, how fraud can contaminate the exercise of power. But it did not start there. It began before with an unlawful house-to-house exercise in 2019, where the GCOM wanted to scrap the existing database and construct a new one, and carried out a house-to-house process which in record 6 weeks purported to register, according to them, over half of the electorate. When we took a full 2 years in 2008, the last time such an exercise was undertaken, to complete the entire country. What was found out in that aborted house-to-house exercise was a clear and present intent to alienate a number of qualified persons to be registered, so that you would have had a very limited and deficient base from the National Register of Registrants from which a voter list would have been extracted, thereby rigging an election even before it was called. That was the first problem that surfaced. Quite apart from the unilateral appointment of the GCOM chair, I have to abbreviate my presentation to give you focus. So that was challenged in the court, and the court ruled, as we all know, that you cannot remove existing registrants from that database, especially, or rather specifically, if they were not resident in the country, because that was the stated purpose of the exercise. To remove from the database persons whom GCOM felt are not resident in the country. And the rationale is simple. The combination of Articles 59 and 159 of our Constitution imbues to every citizen, or imbue to every citizen of this country, a power to register once that citizen is 18 years and over, once that citizen is a Guyanese. No mention of residency, meaning that if you're a resident in Timbuktu, if you're a resident in Sri Lanka, if you're a resident in the United Kingdom, once you are 18 years and over and you're a Guyanese, you can come here and be registered. And once registered, you are qualified to vote. Very simple equation. Very simple. So, Mr. Speaker, we had to then deal with that issue, and that is reflected in the amendments here, as well as in the amendments in the National Registration Act. Wherever residency, we have a duty as lawmakers to ensure that Article 8 of the Constitution is complied with. Article 8 of the Constitution says that any law that is inconsistent with the Constitution is void to the extent of that inconsistency. When we are making laws, we have to ensure, or amending laws, we have to ensure that those laws meet the constitutional litmus test. There are many instances in the current Registration Act and in the ROPA, when it relates to the compilation of the list of electors, that place, rather misplace emphasis on residency. Wherever that has occurred, Mr. Speaker, it is now being removed to bring the legislation, both ROPA and the Registration Act, in conformity with the four corners of the Constitution. So that's a major thrust of these amendments. Second, Mr. Speaker, the public would be well aware that the Chief Elections Officer has a great unnecessary latitudinal width and breadth of power when it comes to the appointment of polling places. GCOM took a policy last election, and possibly previous elections too. A policy, I have no doubt, was made with the best of intentions, that they will use, as far as possible, only public places as polling stations. However, you have places in this country where there may not be a sufficient number of public places. Therefore, you have to, by necessity, to ensure that there is available voting stations for the electorate to exercise their franchise, you have to rent private places. What we found on the last occasion, not what we found, what we made public, was that areas in Georgetown, for example, where there are far more public places that could have been used for polling places, private residences were used. And in my constituency, on the east coast of Demerara, where there is a distinct paucity of public places, polling stations, sufficient number of polling stations were not appointed. When we queried the executive agent, election agent of the PAP, Comrade Zulfikar Mustafa, and I am an assistant election agent, when we queried it to the then Chief Elections Officer, he gave me that excuse that they are confined only to rent, to deal with public places. I traveled around Georgetown and I photographed over 15 private residences that are in close proximity with public places, but those private residences were retained or rented and the public places were not being used. And I presented that to him. And I said, this cannot be fair. Then we had to take a team from the Elections Commission, accompanied by APNU AFC. Basil Williams was part of that team. I can't remember who else. The consultants from the Commonwealth, myself, Mr. Zulfikar Mustafa, and a team from GCOM. Because we had to travel to the East Coast to show the length of villages and to show where the polling places were located. Firstly, they were inadequate in number. They were not properly geographically located, so there was not an equitable spread. But quite apart from the geographic spread, to make it convenient for voters, there was a minuscule number, totally inadequate to satisfy the voting population in localities. So that was a major problem. And what was even worse was that in Guyana, we must always recognize our problems as leaders. We know in Guyana at election times, there are peculiar problems because of the ethnic voting patterns. We know also that there is a propensity sometimes for violence at election time. What we discovered in many areas, persons of one stronghold was taken from that, and the list for which those persons were to vote were located in a distant village, causing them to walk miles or travel miles into a different constituency to cast their ballots. Clearly intended to expose our atmosphere to unnecessary tension and possibly combustion, having regard to our history at election times and what is associated with that. Those were the things that we had to confront, so much so. 3 days before elections, there were a number of big areas where the people did not know where they were going to cast their ballots because GCOM was still not. We had to go with torchlight, floodlight into dark areas of villages on the East Coast to identify open spaces and we accepted their explanation. They don't want to go to houses, and we accepted that. The next alternative, if you don't have a public building, is a public space. So we had to go with torchlight and find playground and empty house lots. And then GCOM had to get tents and equip them overnight for people to go and vote there the next morning. And I say, without any fear of contradiction, as the leader of the opposition will say, the fear of successful contradiction, that there was a pattern. There was a pattern. And you know what the pattern was? Because we traveled both strongholds of the different political parties. Because the APNU AFC was part of that exercise, insisted that we go into areas such as Bachelor's Adventure, such as Victoria over the line, etc. And we went. And the position was not the same. They were not comparables. Only in the PPP perceived strongholds did we have these difficulties. So PPP electorates or supporters didn't know where they were going to cast their ballot 48 hours before elections day. These provisions intend to address that, not to take away the power of the CEO, to circumscribe those powers, regulate those powers, insert into the law factors that he must take into account before he chooses a polling station, and also there's a delimitation of numbers that can cast at one polling station. So we don't have overcrowding. I have said repeatedly publicly, and I'm going to say it again. If anyone, and I've put out this challenge over a year now, and nobody has accepted it, and I hope that someone will try to do it tonight. If anyone can point to a single provision in these proposals which create an electoral advantage for the PPP, I am prepared to stand up here and debate it, rather for any political party. The point I want to emphasize is that any single person who is concerned about free, transparent, and accountable elections in this country will support every single amendment here, because they are all designed to bring clarity, to bring transparency, to bring accountability to the electoral machinery. That is all. Examine them one by one. I can go through. I may not have the time, but they are all here. So let me go to the bill itself now. So clause 6 is amended, and that deals with the establishment of polling station. It says where no public building is available to be appointed, the chief elections officer may rent a separate private building unconnected with a political party or politician and appointed a polling place. How can you have a problem with that? How can you have a problem with that? A large polling place with adequate space may be divided into polling stations. No more than 400 electors to vote at a polling station. How can you have a problem with that? How can you have a problem with that? Factors to be considered in dividing a polling place into polling stations include, this is the circumscription or regulation of the discretion that I'm speaking about. 1, the number of electors on the list. 2, the size of the polling place. 3, the availability of internal and external space in the polling place to accommodate electors lining up at reasonable distance apart. 4, the accessibility of the polling place for persons with disability. How can anyone find this objectionable? And also, the chief elections officer, later in the bill, is mandated to give notice X number of days, I believe 5 days before polling day. He has to publish the list of polling stations for all to see. How can that be wrong? There's a provision, I believe, for last minute changes, but as far as possible, he has to publish the notice to poll, the list of polling stations in the official gazette for everyone to see. How can anyone concerned about transparent election find that in any way objectionable? Then, Mr. Speaker, we have the division of the polling districts into subdivisions. And this is a direct answer to Claremont Mingo shenaniganism. A direct response to him. There's no 2-3 ways about that. We have countries in the world where millions and millions of ballots are counted and results are declared within a matter of days, weeks sometimes, depending upon the number. We have a couple thousand ballots in Region 4 that took us from March to August to count and resolve. How much was the total ballots in Region 4? What was the total ballots in Region 4? A couple tens of thousands of ballots. About 160,000 thereabouts. About 200,000, I'm told. It took us 6 months to count that. It means, unfortunately, that we are unable to count 200,000 ballots properly, fairly, and in accordance with law. And that was on display at Ashmin's building, and the stories are now unfolding before the Commission of Inquiry to refresh our memories if it is becoming dull. So We proposed Region 4 first, as that was the problem region, and no one can dispute. No one can dispute that that's where the problem arose. Then the opposition party said, that we are singling out Region 4 because it is their stronghold. We rejected that because there was nothing to do with stronghold and weak hold. It was where the problem arose. But we consulted, and I believe the Private Sector Commission and some other electoral body came to us and said, look, just to appear even-handed, and we are, just choose another two regions or another region that is considered a PPP stronghold and do the same thing. We are motivated by no sinister motive, and therefore we are unopposed to such a gesture if it can bring the opposition on board, because we want the opposition to embrace these changes. After all, whether I like it or not, you are the major opposition of the country. I don't know how long that will remain so, but you are a major player in the electoral equation, and therefore you must have a say. You have the support of a significant constituency in this country. So honorable members, what we did is what we were proposing originally for Region 4, we replicated it in Region 3, a known PPP stronghold, and in Region 6, a known PPP stronghold. So if there is any disadvantage by the subdivision, the PPP is suffering it more by 100%, because we have two and you have one. That is the extent that we are going to satisfy the queries that you have raised. So Region 3, Mr. Speaker, is now divided into three, and what we have done is not created unknown divisions. We used existing polling subdivisions within the polling districts. All of us who have done election work at election time would be familiar with the different regions and the polling subdivisions within the region. All we have done is use those same boundary demarcations so that for GCOM, they will correspond with the existing electoral division system in their system. So there is not much, there is not going to be much work for GCOM to do when they have to enforce this legislation. So Region 3 is divided, as it is now divided, but in Pole District, it is now divided into Essequibo Island and River Subdistrict, that's one, 2, St. Lawrence, Cordilla Ida Subdistrict, and 3, Hague to Arabio Creek Subdistrict. Now, what this amendment seeks to do is to replicate the identical structure which exists in the polling districts and to put them in sub-polling districts now, whereby you will still have a returning officer, but in each polling sub-district, you will have a supernumerary returning officer who, for all intent and purpose, will perform the very function that the returning officer would have performed for the entire region. So in Region 3, you will now have 3 tabulations being done instead of a tabulation being done in a central place. Each of these sub-districts will be tabulating their votes, and they will be sending their documents straight on to the elections, and all of that is outlined to the CEO, to the chairman of the election, because we amplify the persons whom documents have to send to, so that no one person will hold election documents at a ransom anymore. And we'll also send it to the RO, and the RO at the end, of course, they will have to tabulate. The supernumerary returning officer will tabulate in the same way that the RO tabulated, allowing all election agents, the observers, etc., to participate. We specify how he must tabulate. No breadsheet and spreadsheet, but he must use the statements of poll. He can project it on an electronic mechanism if he wishes, but the basis of the tabulation must be the statement of poll and nothing but the statement of poll. If there is any transposition from the statement of poll, then it must be done in a transparent way and with the concurrence of all the participants in the process, the statutory participants, and they are listed there. And these aggregates of these totals will then send to the RO, who shall declare. These regions, these supernumerary councils also, they shall, supernumerary returning officer also shall declare. The RO shall declare as well. So we have, and then, but I'm going to deal with that later. So that is region 3. Region 4 is East Bank Subdistrict, North Georgetown Subdistrict, South Georgetown Subdistrict, East Coast Demerara Subdistrict. And Region 6 shall be East Bank Berbice, the Kanji Subdistrict, Upper Quarantine Subdistrict, and Lower Quarantine Subdistrict. Right? So I hope that you understand what will happen there. Now the SOPs are going to be sent to the CEO and to the ROs and to the chairman of the commission. The ROs, upon receipt, must post on the website. Must post on the website. If the RO fails to do that, and he must do it upon receipt. So within 24 hours, all the SOPs should be on our website. Then the CEO, if there's a default on the RO, must also post to the website. So within 24 hours, all the results are known in the country. And of course, with the various duties that are being created here, if there is any breach of these duties, serious criminal offenses are created and high fines and high term of imprisonment are imposed. Discipline forces, when the discipline forces cast their ballots, then it is inked and that it's crossed off, and that list is put into the ballot box and sent to the polling place where that person was registered to vote. So that is to guard against voters' impersonation. We clarify the position of identity papers, and it's now stated what is acceptable as a form of ID, but a valid passport is now acceptable. Any person who refuses to allow a voter to vote when that voter presents a valid ID is also liable to some serious offenses. Any person who impersonates a voter is subject to a number of offenses as well. Anyone who obstructs voting day activities shall be liable for a series of offenses, etc. Then, of course, we deal with how the votes are totaled. Clearly, at the polling stations, the amendments set out how the votes are to be counted, who are to be present, how the presiding officer must listen to the queries from the various persons and must sign off only when there is a consensus. Very transparent process of counting. And then when the count is finished, of course, like what exists now, the results, a statement of poll is posted there at a conspicuous part of the polling place. Anyone who removes that statement of poll also commits a serious offense. Mr. Speaker, also we deal with post-tabulation now and with the declaration of the results. And clear directions and guidelines are now set out to allow, well, rather to guide the chief elections officer on how to compute the results and how to aggregate and what he must count as valid votes and what will be the total results, which he will do in accordance with Section 96 to pass over to the Elections Commission for those to be the basis upon which the election results, the Election Commission will declare the results. Mr. Speaker, we have also mandated the CEO a time period once he is in receipt of all the aggregate numbers from the various regions. He has 12 hours to compute his results in accordance with Section 96.
Honorable AG, as we are on time, you will need an extension of time to continue.
Thank you, Mr. Speaker. I'd like to ask that my colleague be given 5 minutes to conclude, please.
Thank you, Honorable AG.
Thank you, Mr. Speaker. Mr. Speaker, he has 12 hours from the receipt of the documents and the numbers to calculate and give to the Election Commission. So he will not be operating, as the CCJ said, what was the word they used? They use a Western word in them cowboy movie. What was it? I can't remember. Yes, he was a lone wolf or something like that. Yes. Lone Ranger. That was it. I remember. Thank you, Mr. Ramsey. He's not a lone ranger and he doesn't operate on his own time frame. He now has a statutory mandate. And Mr. Speaker, there is a fine of $10 million and imprisonment for 10 years for breach of these obligations. Mr. Speaker, the Election Commission publishes manuals, and I have no doubt that they do so with utmost bona fides to guide their election staff on election day on how to perform their respective functions. What we have found, and all electioneers in this house will agree with me, that on election day, sometimes when push comes to shove, crunch time, you have to argue with a presiding officer or some junior staff in the machinery about what the manual says or how the manual is being misinterpreted. Most times, Mr. Speaker, well, on every occasion, the manual ought to be in conformity with ROPA, the statutory code by which elections are conducted in this country. Sometimes the manuals collide with ROPA, or sometimes they contravene ROPA. But to convince a junior staff on election day of that is an impossibility. They are following that guideline, that manual, like a Bible, and that can lead to problems. When you try to get onto a CEO or an RO, you have great difficulties. What we are stipulating now as a matter of law, that any manual that GCOM wishes to use, and they have the autonomy to use any number of manuals that they wish, they must make them public at a period of 30 days after proclamation. 30 days before election day, they must make those manuals public so that they cannot change them after making them public. So that we have the time, all political parties have the time to scrutinize those manuals and find objections to them. Mr. Speaker, I am sorry that I have had to hurry my presentation. As I said, it is impossible for one to cover the breadth and width of the amplitude and gravity and magnitude of the menu of proposals that are here. They are wide-ranging. I know that there are many speakers after me who will speak, competent, experienced politicians in the election field, and I have no doubt, Mr. Speaker, that they will carry the baton on and further explain the various facets and tenets of this bill. Mr. Speaker, this is a good piece of lawmaking which every sensible Guyanese should throw their full support behind. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. Our next contributor is the Honorable Member, Mr. Manza Walton. Just before the honorable member starts her contribution, I would like to call on the Honorable Minister of Parliamentary Affairs to move the suspension of the standing order so that we can continue with this sitting to the end of the business of the sitting.
Speaker, I'd like to move the standing order to allow for the sitting to continue until the conclusion of the order paper today.
Thank you, honorable members. The motion is moved. Those in favor? Those against? Ayes have it. We are going to go beyond the 8 o'clock hour and to conclude when the business of today's sitting is done. Honorable member, you may now make your contribution.
Thank you, Mr. Speaker. Mr. Speaker, I wonder why is it that before I've gotten a word in edgewise, the honorable member seeks to distract. And that's a good thing. Predictability is a very, very good thing when it comes to governance. But you wouldn't know that, would you? Anyway, Mr. Speaker, I want to thank you for the opportunity to make my presentation to the Honorable House on this bill before us for consideration. It is absolutely important, and I have to agree with the Honorable Attorney General. He went into great depth and took great pains to point out that this is indeed a matter of gravity. In fact, Mr. Speaker, the Representation of the People's Act is intituled as an act to make provision for the election of members of the National Assembly under a system of proportional representation and for purposes connected therewith. I agree with the Honorable Attorney General that this bill is indeed a very weighty one. I noted that he indicated that he could not, at this time, go through in detail the provisions as set out. I want to propose to the Honorable Attorney General that given how grave and important this is, that the place for us as members of parliament, that the place for us as representatives of the people is to take this bill, you're absolutely right, to a select committee where we can clause by clause peruse the amendments that are being proposed. To quote the Honorable Attorney General, Mr. Speaker, who with an interest in free and fair elections, and who with an interest in law and order would oppose this honorable house sending this bill to a select committee so that we can peruse these amendments one by one to understand and to get clarification from the Attorney General for the rationale, sir, for the proposals contained herein. Mr. Speaker, the AG himself, the honorable member, pointed out that it is 63 pages in length and the amendments are wide-ranging. Mr. Speaker, I doubt that a responsible assembly would seek to tonight, in the dead of night, foist upon the people of Guyana, sir, a bill that has not had the scrutiny of the select committee, bearing in mind the importance that the Attorney General has outlined that it has. Mr. Speaker, the Attorney General referred to a number of the main policies of the bill. And what I want to say to us tonight, and I said it on the last occasion that I stood here, is that the PPPC conveniently remembers history. The PPPC, in the person of the Attorney General, has come here to say to us that the reason for these amendments is what happened in 2020. Again, Mr. Speaker, operating as if Guyana's history began in 2015 to 2020. And Mr. Speaker, I want to say that and caution us that we really should not, as a responsible assembly, ram these amendments down the throats of the people of Guyana using their one-seat majority. The Honorable Attorney General himself said and acknowledged that we on this side of the House represent a significant proportion of the people of Guyana. And should the Attorney General be interested in fairness, I do not think that he will want to go on record as denying what he has said to be a significant proportion of Guyanese the opportunity to have their representatives, now that a bill has been presented to us, to peruse these amendments section by section. Anyone interested in law and order and democracy and all of the other tenets that you have said will not, sir, will not resist such a call. Mr. Speaker, the representation of the People's Act, as admitted by the Honorable Attorney General, touches and concerns the entire legal framework for elections. It directly impacts a number of pieces of legislation, Mr. Speaker, and it is important that as representatives of the people, we be given the opportunity to provision by provision peruse these proposed amendments to make sure that we are satisfied with what is being proposed by the government. The Attorney General does not get to come here.
Honorable members, I was able to listen to the Attorney General. I would like to listen to the Honorable Member now presenting. Go ahead, Honorable Member.
Mr. Speaker, I thank you for that. Mr. Speaker, we on this side of the House will say that we support electoral reform. Unequivocally, we support meaningful, we support honest and earnest electoral reform. Let the record show. What we will not support, Mr. Speaker, is the PPPC administration coming to this Honorable House, like I said before, to foist these provisions upon the people of Guyana. Mr. Speaker, the honorable members on the other side of the House must know that public consultation and scrutiny of a piece of legislation by a select committee are two completely different things. So, Mr. Speaker, let them not come with that excuse. Mr. Speaker, I want to say this, because my task tonight before us is to examine the context within which these amendments are proposed. And just like the Attorney General, I have colleagues who will speak after me who will competently acquit themselves of the various aspects of the bill. Mr. Speaker, we can predict with certainty what will be said here tonight. Just like the Attorney General started with the 2020 elections and Mingo and all of these things. Mr. Speaker, I want to say this. We know that this is nothing short of gimmickry. Mr. Speaker, The PPPC administration knows that as at today's date, any talk from them about democracy, about transparency, about good governance is simply that talk. Mr. Speaker, the people of Guyana have had 2 years to see and to assess the PPPC administration. And Mr. Speaker, I will say today that the people of Guyana have seen that this country, Mr. Speaker, that this country is in a state of democratic backslide, the likes of which we have never seen before. Mr. Speaker, the guardrails of our democracy are so brazenly and so wantonly being eroded, Mr. Speaker. Brazenly and wantonly. And Mr. Speaker, when we talk about democracy, the PPP wants us to pretend as if they are the bastions of democracy. When if we recall, Mr. Speaker, even the so-called branded guardians of democracy have parted company with them and are now openly critical of their corruption, their greed, and their avarice. Mr. Speaker, I am addressing before us the context in which the PPPC is seeking to move these amendments. Mr. Speaker, they have come into this House with the hopes that they can rally the people of Guyana to support them with cries of bingo and who rigged and who didn't rig, Mr. Speaker, and they're doing it with the sole aim of distracting from their mismanagement of the economy. They are doing it with the sole aim of distracting from their inability to bring relief to the poor and working class Guyanese. Mr. Speaker, the lived reality of the people of Guyana today is blackout multiple times a day, dirty water coming through their taps, if any water at all, and the average man struggling to put food. This is the context in which, Mr. Speaker, the PPPC is coming today to ram these amendments down our throats. Mr. Speaker, let me say that, they can scream and detract all they want, but it does not take away from the lived reality of Guyanese. Mr. Speaker, I want to address our minds to the theoretical underpinnings of what is being brought here before us. I anticipate, Mr. Speaker, that from the array of speakers we will hear ad nauseum about the 2020 election and the threat to democracy and all of that. Mr. Speaker, the truth is that for decades now, the call has been clarion for electoral reform, both by international observers and by Guyanese and civil society. Mr. Speaker, these calls were not born out of thin air. Events happened. Events before March 2020. Mr. Speaker, we remember in 2011, when the then CEO presented to the Commission the allocation of seats, you purportedly arrived at using a formula that he never presented to the Commission, but he arrived at a result. Mr. Speaker, we remember that. Thankfully, Mr. Vincent Alexander caught him in the act. Mr. Speaker, Guyanese remember in 2006, when the same CEO announced a result, sir, that was not in keeping with the votes cast and resulted in the AFC in Region 10 being denied their rightful seat. Mr. Speaker, we remember in 1997 when the then chairperson left a meeting of the commissioners, went, swore in the late Mrs. Jagan as president, unbeknownst to the rest of the commissioner. And our history records, Mr. Speaker, the throwing over of the writ over your shoulder, the greatest act of judicial disrespect that we have ever seen as Guyanese. Mr. Speaker, so the PPP doesn't get to come in here tonight to pretend to be the morality police. They don't get to come in here tonight to be the morality police. And Mr. Speaker, I make this point to say that as a House, we have two options. We can come here and we can continue to point the finger, or we can get down to what the people of Guyana deserve: proper, meaningful electoral reform. And Mr. Speaker, what that does not look like is what the PPP is purporting to do here tonight. Bring amendments, use the tyranny of your one-seat majority to foist it on the people of Guyana. That is not what meaningful electoral reform looks like. So, Mr. Speaker, we have to be serious about what we're doing. I want to say that I sat and I heard the Honorable Attorney General go through the raft of promises that they have delivered to the people of Guyana, and he has named this as one such. On the last occasion I was here, Mr. Speaker, standing in this very spot, I spoke about the quality of the legislative enactments that we are purporting. Mr. Speaker, it is not about ticking promises. It is also about qualitative elements of what we are doing. And Mr. Speaker, I am submitting to us tonight that there is no way in one night we can go through and assess the quality of this bill in this session, Mr. Speaker. It needs to go to a select committee. Mr. Speaker, I want to say that the government, for all intents and purposes, Mr. Speaker, is not serious about electoral reform. They're not serious. And their attitude, Mr. Speaker, says to us that they have no intention of getting down to real, meaningful reform. Mr. Speaker, very, very important to this issue of electoral reform. Bearing in mind, sir, I will say that the IRI recently concluded a poll which showed that 38% of the people of Guyana did not believe that the results reflected the will of the people. And 81% of the people of Guyana want electoral reform. And I am submitting to us tonight that that does not look like the PPP coming to ram down our throats these amendments. Mr. Speaker, I want to look at a few elements of the bill in terms of the context within which this bill is brought, Mr. Speaker. Mr. Speaker, when we look at the issue of fines and penalties that the Honorable Attorney General addressed here tonight, we note, Mr. Speaker, the very draconian, sir, fines and penalties that have been placed in this bill. Mr. Speaker, these are matters that ought to be properly discussed. Because, Mr. Speaker, not only us on this side of the House have raised the objection, noting, sir, that what this does is deter qualified, competent people from participating and working with GCOM to administer our elections. Mr. Speaker, the honorable members on the other side of the House can heckle, they can say whatever they want to say. It does not change the reality that the fact is that this will serve to deter qualified, competent people from being employed with GCOM. Mr. Speaker, I'm finding it very difficult to rationalize the draconian penalties in view of this particular fact. We are driving away qualified people, Mr. Speaker. Why would a qualified person want to work with GCOM? If it is a case where a genuine, for example, mistake is made and they're facing draconian fines and penalties, unless, Mr. Speaker, that is the intention. One must wonder, is the intention to dissuade competent, qualified people from manning our election system so that it could be stacked? So that it could be stacked with persons favorable to the PPPC administration. One must ask the question, Mr. Speaker, and just so that we know that this is not conjecture, they must tell you that they objected to 72 persons. 72 persons who were appointed to be officials at the upcoming LG. They wrote objecting to those persons, to the CEO. And you know what the CEO responded to say to them? Listen to me, if you are going to object to these people, we already have such a challenge with manpower that the LGE will not be able to come off at the time that you want it to come off by. They must tell you that. So, Mr. Speaker, this is not about conjecture. Mr. Speaker, this is a live situation that is happening right now. Right now, as a result of these proposed amendments. Mr. Speaker, we have to ask the question whether this is the motive. Mr. Speaker, you know, it doesn't strain credulity that the PPP would want to stack the system with people that they view as their people. Mr. Speaker, they will be, as the government, in a position to offer persons that support them the protections from the type of prosecution they are prescribing here in law. In other words, man, you do your thing. We got you covered. Mr. Speaker, it does not strain credulity when the PPPC has demonstrated their willingness and their ability, sir, to shelter their agents who are involved in wrongdoing. Mr. Speaker, in my own portfolio, I am thinking now of our High Commissioner to India, Mr. Speaker, who for all intents and purposes unleashed the vilest of attacks against a female in India, and he is still sitting comfortably as our High Commissioner. So, Mr. Speaker, they have demonstrated this ability to protect their people who are involved in wrongdoing. So they're going to tell them, y'all go, we got you covered. We will not allow you to be charged. That is the motive, Mr. Speaker. That is the motive. That is the motive. Let us not fool ourselves, Mr. Speaker. They want to stack the system with their people. Mr. Speaker, I want to say that, thank you for recognizing that I am a special talent, Honorable Member Nandlal. But I will say this, that we on this side of the House, in taking up what the Attorney General has said, are not opposed to electoral reform. We are willing to support the amendments as long as we are satisfied that they meet the criteria, that the rationale is sound. And Mr. Speaker, I am repeating here that we will be able to do that in a select committee, sitting with the government and reviewing these provisions one by one and bringing it back to this Honorable House to say that this is an effort that we have made collectively. Mr. Speaker, the point that I want to make Mr. Speaker, I can't help but be amused by the Attorney General's statement that I have not made one comment on the bill. I'm not sure. Well, anyway, he left the room, so he must not have been following. Mr. Speaker, in excess of 46 amendments, and the Honorable Attorney General has indicated that he will not be able to go through all tonight, but is trying to take me to task for not rushing. Mr. Speaker and Honorable Member Nandlal, this is my 30 minutes, and therefore I will say what I want to say on the bill. You will not prescribe what I say. Mr. Speaker, the final point that I want to make in terms of the context within which this bill is brought is that, as noted by the Honorable Attorney General, there are a number of interrelations with other pieces of legislation. One we will consider here tonight, Mr. Speaker, the National Registration Amendment Bill, Mr. Speaker. The electoral laws, Mr. Speaker. There is a Webster of provisions, and we are not satisfied on this side of the House that they have been able to be properly and thoroughly reconciled. My suggestion, as the honorable member and the other house has asked, is for us to take this to a select committee so that we can review it. Anyone interested in transparency and democracy will not object to that. Mr. Speaker, I want to turn our attention to Part 4A, the preparation of the official list. And I will give you, for example, Mr. Speaker, one concern that we have on this side of the House that we believe has not been properly ventilated in terms of the rationale. Mr. Speaker, if the Commission saw the regs by order, notwithstanding anything contained in any other written law, the electors to choose the members of any local democratic organ other than a regional democratic council or other local government authority shall consist of names extracted from the official list of electors under this section and registered with an address of the local democratic organ or local government authority. Mr. Speaker, the Honorable Attorney General went into detail to speak, well, not detail, he mentioned in passing the issue of residency. Mr. Speaker, we believe that this is a matter that requires much, much more thorough interrogation to come to a position that is progressive and that is responsive to the reality on the ground, Mr. Speaker. That is what we truly believe. And so we are asking, Mr. Speaker, and my colleague, the Honorable Shadow Attorney General, will speak to this in greater detail. Mr. Speaker, we want to examine Section 87 in terms of the context again. And the Honorable Attorney General mentioned the issue of the supernumerary officers. Mr. Speaker, the question arises as to the capacity of the system with these new manpower requirements that we are imposing. Mr. Speaker, how has that been studied out? What are the implications for GCOM? What are the implications for its operating costs, Mr. Speaker? These are all very pertinent and relevant issues that have to be considered. Mr. Speaker, the Honorable Attorney General mentioned as well, sir, the issue of premises for which polling stations must be located. Mr. Speaker, for example, we wish to recommend that the House considers, and this is something we can speak more to in a select committee, that the House considers perhaps giving parties the option of a no objection rather than leaving this to the chief elections officer. So, for example, the opposition parties may say, look, We do not agree with this premises. We agree on this one. Mr. Speaker, that is an option that is not explicitly spelled out and should be explicitly spelled out. Mr. Speaker, the other issue that we want to look at in terms of the interrelated nature of this, Mr. Speaker, we want to look at two issues.
Before you look at the two issues, I'll need to give you some time.
Yeah. Could I ask that the member be given 5 minutes to conclude?
Go ahead, honorable member. 5 minutes to conclude.
Thank you, Mr. Speaker. Mr. Speaker, I have 5 more minutes, and in that time, I wish to say to us here, sir, that these over 46 or so amendments require a thorough examination. Mr. Speaker, we will continue to repeat on this side of the House that we require, as the representatives of 49% of the population, as the Honorable AG stated, that this bill go to a select committee so that we can review it. Mr. Speaker, I will say that this issue of consultation and public consultation is a different matter from when a bill comes into this House, that it should invoke the parliamentary procedure of being sent to the select committee. Mr. Speaker, in wrapping up, I want to say this, that we have to be serious, and we have to be serious in this House about electoral reform, Mr. Speaker. Mr. Speaker, we are standing here and we are talking about this wide and sweeping ROPA. And Mr. Speaker, they are low-hanging fruits that we can pick, Mr. Speaker, to demonstrate to the people of Guyana that we are really interested in free, fair, and transparent elections. Mr. Speaker, this issue of biometrics at the place of poll, any person, Mr. Speaker, interested in free and fair elections, why would they, to use the Honorable Attorney General's words, why would they, sir, reject this issue of biometrics at the polls? Mr. Speaker, they are saying, oh, it precludes people from voting, when the truth of the matter is, Mr. Speaker, all that it is doing is confirming that you are who you say you are. Which person interested in transparency and in fairness, Mr. Speaker, will resist that? Mr. Speaker, one other observation, and this is in the context in which this bill is brought. Mr. Speaker, I note that there is a hearkening back, Mr. Speaker, to the 2001 list or the 2001 database. And given that these matters are interrelated, sir, I wonder whether the AG can make clear here tonight why we are not referring to the 2008 database that was created, sir, out of that house-to-house exercise. Mr. Speaker, to quote a document from GCOM, it says the imperative to conduct the 2008 house-to-house registration exercise was born out of the need for the creation of an indisputable national register of registrants, which could be used as the basis for the preparation of electoral lists that would be commonly acceptable by all stakeholders as being unblemished. Mr. Speaker, when taken together, this act and the amendments to the NRA seeks to bypass that 2008 NRR that was created to refer us back to a 2001 NRR, Mr. Speaker. Mr. Speaker, it appears to me that the result of that would be to disavow that 2008 NRR, harken back to 2001, Mr. Speaker, and what the intention is, I am presuming, is by the operation of the law to allow for people who did not present themselves in 2008 to be registered to somehow be brought back in through the back door. The result of which, Mr. Speaker, if we continue on this trajectory, would be that Guyana will soon have a voters list that exceeds its population if we continue on this route, Mr. Speaker. It cannot be that in a democratic society, we are going to say to the people of Guyana that our hands are tied, that dead people who have died overseas, whose deaths have not been registered here in Guyana, must remain on a list, must provide an opportunity for mischief, and we in this honorable house can do nothing about it. Mr. Speaker, that is an unacceptable position for us to put to the people of Guyana. Mr. Speaker, what I have attempted to highlight here tonight is that this matter is a complex and far-reaching one, Mr. Speaker, and the people of Guyana are far more deserving of proper review and not a 3-hour debate in which we will come, trade words, and they will foist down the throats of the Guyanese people. A sham of an attempt at electoral reform when the people of Guyana deserve deep, meaningful reform, Mr. Speaker, to curb this current trajectory of democratic backslide on which we find ourselves. Mr. Speaker, I thank you for affording me the opportunity.
Thank you very much, Honorable Member. And now for the Honorable Minister of Home Affairs, Brinley Horatio Ben.
Thank you, Mr. Speaker. Mr. Speaker, it's really difficult and still somehow traumatizing. So, hear the honorable member who just spoke before me go through a presentation which basically suggests that the APNU-AFC has no real interest in electoral reform, in dealing with the questions which we have experienced, which we have suffered by in relation to the questions of elections in Guyana. Subversion of our democracy, the criminal acts which were perpetrated in relation to the elections, as recent as the 2020 elections, but in fact which go several cycles, several decades, several elections periods, where they, in the form of the PNC, and later the APNU, and now the APNU-AFC have been involved in elections rigging in Guyana and subverting the democracy of our people and stealing the will and the votes of our people. It is indeed a tragedy that such a younger person, educated, erudite, but irrational, and not paying attention to the facts of the matter and the historical reality and experience of the Guyanese people in elections. It's really, really a tragedy. And the fact that she has been put as the lead, the first speaker on that side, in respect of this matter, ahead of other persons, ahead of the Rambutans and the others, and some who are not here, ahead of Ms. Walda Lawrence, to present on this matter speaks to the continuing insidiousness of this political party, the APNU-AFC, on that side of the house, in respect of continuing to undertake acts, to undertake stratagems in relation to continue to undermine, to suborn, to destroy our democracy and the peace, the security, the goodwill, and the proper living together, the coming together of the Guyanese people. The problem of elections is the one which, whether you say it is ethnic voting, whatever kind of voting or whatever, is the problem where advantage has been taken of ethnic differences and other differences to hold on to perceived vote banks, to hold on to enclaves, to hold on to persons who are kept in thrall, who are kept captive by political messaging of a negative form merely for the position, merely for the intent of holding on or attaining political power wrongfully. The AP and UAFC in this house, even though the member before me, honorable member, Ms. Desi, who spoke before me, said that they were somehow in support of electoral reform. The AP and UAFC in this house and in this place owe the Guyanese people an apology. Owe the Guyanese people an apology. And I thought that in putting the young lady to make the presentation without resorting to the other known acolytes in respect of electoral malfeasance, I had hoped that the young lady would have been the one to proffer the apology to the Guyanese people, and that we would have been able to take a new path, take responsibility with respect, following introspection, retrospection, take account of our failures perhaps in respect of these matters, and let us go forward to a new plane, accepting what should be for our people, for the future of the people, for our country. Now we are at the most propitious moment in our economic and social and hopefully political development. And so the presentation just now, in the context of what is intended in this representation of the People Amendment Bill, is disgraceful. It's disgraceful. It is disgraceful. And I am deeply disappointed. I am deeply disappointed that the young lady would have been allowed to and would have enjoyed the moment in deflecting, avoiding, and taking account of the real need and resort here in this amendment bill to fix issues which were clearly not properly operated on or which had to be dealt with in relation to the most recent experiences in elections. Do I continue to say that we had problems in 2015? Of course, there were boxes which should have been opened and counted, 20 odd boxes, 21 boxes. There were issues as usual with voter suppression, which were talked about. There were issues in relation to preventing people from getting to vote. There were issues of people being threatened and locked out of places. You either couldn't come out of the box or you were threatened, and there were people going around with guns threatening polling agents in 2015, and even before that in 2011. There's a long list of what are crimes in relation to the question of assuring the free and democratic will of the Guyanese people in voting to elect a government to represent the people of their choice. The honourable member speaks to going to a select committee. I am aware that there was widespread national consultation on this matter. I am aware in this very place that the opportunity was afforded for consultation with the political parties, either as groupings or individually. I'm aware that there was a walkout in respect of this matter too by the honorable member who just spoke before me, amongst other persons. Walked out on the question of the consultation on this document. And now coming here, having had over a year, and then the specific forum, the specific engagement to have the clause by clause consultation on the matter in a public forum, walked out and now coming here to say you want to go to a select committee. Insincere, of course, natural for the AP and AFC, and I have to say this insincerity is a trademark of theirs, along with the willingness, the intent, and the interest to always take illegal resorts to undertake fraudulent measures in respect of elections. It's in their DNA. It's in their DNA. It can't be changed. They will always attempt fraud at elections in Guyana. Always. The rigors by nature. And it cannot be changed. And the fact that you have a Ramjatan and some others who have recently joined up with them will not change it. And the fact that persons who were participants, willing participants in the great fraudulent 2020 elections exercise can sit here unashamedly and enjoy this debate speaks volumes as to their nature, their intents, and their continued willingness to continue fraudulent resorts in respect of elections in Guyana. The honorable member before me talked about that there's no real interest in the working class people, that there's no real intent in working class people, no real interest rather, and that this engagement is merely a talk, and this document is a gimmick. And every time they've had the opportunity, particularly from 2019, I believe, in respect of the NRR, in respect of the appointment of the GCOM chair in the form of a Mr. Patterson, and all the stages, all the efforts which are made at the courts to change the undertakings they did in respect of the electoral laws and the proper conduct of elections, they lost in the courts. They lost in the courts. And in spite of all of that, not only in Guyana, but at the CCJ, the apex court, they lost. In spite of all of that, a young trained Guyanese lawyer would be the first speaker here to speak on this matter and to say that this document, the changes, the amendments in this document, which are clearly intended to protect the electoral system, the machinery from malfeasance, continued malfeasance, from distortions, from any issue, preventing any issue which will thwart the will of the Guyanese people, and which were given by repeated examples from the presentation of the Honorable Attorney General. They would come here and say that this is gimmickry, this is not useful of itself, and really should go to a select committee where I expect there will be great time wasting, and in fact would bring us into problems in relation to the holding of the local government elections. In fact, I don't think they want to hold I don't think they want to partake in local government elections. They don't want local government elections. They only like elections when they can corrupt it, frighten people, terrorize people, conduct fraud, bully people, chase people out, beat people. That is when they like and want elections. It's historical, it's documented, it's historical and documented. And so I think fundamentally that this document gives us the information, the results, the platform to move to a new and better stage in relation to the conduct of elections in Guyana. That the members on the other side would gladly embrace the amendments in this document in relation to the conduct of polls, in relation to the provision of the supernumerary officers, in relation to the placement of polling stations, in relation to, of course, what were termed draconian fees, fines, and imprisonment in relation to misconduct by persons who are elected, who are appointed to conduct the elections according to the spirit, letter, and intent of the Representation of the People Act and the Constitution of Guyana. There's a suggestion that it may deter some people from wanting to become elections officials. If it deters anyone, it would be those persons who would have either the subliminal message or the distinct intent, or would have been placed to conduct the elections in an improper way. And so what is termed draconian in terms of the fines and imprisonment is appropriate to bring this great disgrace to an end, the question of electoral fraud in our country. It's disgraceful. It's disgraceful. And not only regionally, internationally. We were here 5 or whatever months, as was said, to count 200,000 or whatever number of votes. We had all kinds of shenanigans in relation to watching, protecting the ballot boxes. The most distressing moment in Guyanese history over the last 3-4 years were that period, those moments. But I wouldn't make it personal. I am not going to make it personal. Not now. I am not going to make it personal, no. But I would still have to thank, Honorable Member Priya Manichan and Dr. Frank Anthony for coming to my aid and assistance while I was still out there. But I'm not going to make it personal. I never will. So, the most important thing, totally and in context with this document, is for an open admission to be made by leading members of the APNU AFC to chart a new course, to accept wrongs which have been done, either in their name personally or as a grouping, and to recognize that what is required for the stability, the proper development of our country is to fix this problem. There are other problems which we should be paying more attention to. The question of the sovereignty on the western border, the question in our discussion in terms of the budget, in terms of making the most efficacious use of the monies for development, the question of how do we restore our agricultural sector, the mining sector, the bauxite people who suffered because the river was blocked, the Berbice River was blocked. the incredible imposts which were made on the life of the people by way of VAT and other imposts while they were in power. Those are the things we need at this moment to get past and to agree on a new approach as to how we will protect and develop our people. But unfortunately, the door is not closed, of course, but unfortunately, the first presentation which was made here does not help it. Does not help it. I would want to posit that in spite of course, in spite of the opportunity of making a long speech, but that we should spend more time, take the opportunity to go through it, the presentation and the review, clause by clause with the Honorable Attorney General, because of course it's 40 odd amendments, and it would not help for me necessarily to go speaking beyond what I've already said, given the seeming time constraint and the necessity to specifically identify the clauses here which need to be dealt with in committee. So with that, Mr. Speaker and honorable members, I fully support the amendments in this bill, fully support these amendments. I recommend it to the House. I say again, it provides us with the opportunity to gather around, put our minds together around the necessity for accepting and working with these amendments and making it work for our elections so that we could protect our democracy, so that we could protect our people as we go forward in the ennobling task of developing our country. The ennobling task of developing, bringing together a multiracial, multi-ethnic, multicultural, multi-religious country, remarkable to any other place in the world. The failures which we have had so far are resident in the changes which could be brought around by way of these amendments on the question of this democracy here in Guyana. And we have to acknowledge our collective failures on the matter. This document provides the opportunity to get around and get past and above these collective failures in respect of electoral democracy. And it is for that reason that I fully support and commend this bill from the PPPC in relation to further strengthening democracy, democratic culture and behavior in this our country, Guyana. Thank you very much.
Thank you very much, Honorable Minister of Home Affairs. And now for the Honorable Deputy Speaker, Mr. Lennox Schumann.
Mr. Speaker, can you hear me?
Yes.
Let me place firmly on record, in the unlikely event that we will have some technical difficulties, I want to place firmly on record that this bill enjoys my 100% support. It was only about 2 weeks ago, Mr. Speaker, that I testified for the Commission of Inquiry on Elections in Guyana. I have had to go through the very horrifying task of having to identify what transpired after the March 2nd polls closed and everything that ensued after voting and with Region 4. I have had to relive minute by minute all of the events that transpired. It is the first time in my life and in many other young people's lives that they would have had an opportunity to vote or to witness an election. And what the people would have seen would not be representative of what the future Guyana should have looked like. I remember some of my colleagues. When I say colleagues, I'm talking about opposition colleagues who were in the House, who were part and contributors to the possible theft of a nation. I remember very explicitly, Mr. Speaker, having to pick up the Honorable Robson Ben right at the back of the very chamber where Parliament is held now, after he was thrown over a rail. These things should not happen in a modern democracy. I am taken aback by my parliamentary colleague, Ms. Desir, on her presentation, speaking about sending a bill to committee. And the reality as it stands, Mr. Speaker, is that there are members in the opposition who want to send this to committee, who want to hinge it on constitutional reform and to tie the two of them together. But yet, in their quiet conversation, they have no intent, no appetite to support constitutional reform. So essentially, what my colleagues in the opposition want to do is to send this bill to committee so it can die a slow and painful death and have no reform executed on the electoral system. The reality, Mr. Speaker, is that having been a witness to what transpired post March 2nd, 2020, I will say that these reforms are desperately, desperately needed. The fact that you may not have requirements for biometrics at a polling station does not eliminate the possibility of that. Having so many lawyers on both sides of the House who are more amply qualified than I am in legal matters, they would know fully well that Article 163 gives the Guyana Elections Commission the authority to utilize whatever measures they have to ensure that the process is fair and transparent. What this bill does not do, it does not hamstring the Guyana Elections Commission from being innovative in how they conduct polls. It opens the door for the Guyana Elections Commission to now explore those possibilities. And I will say, Mr. Speaker, and I would rather be very short, very succinct, and to the point. There is no point in beating around the bush. This bill does exactly what it needs to do to ensure that what transpired in 2020 never happens again. Mr. Speaker, that is where I rest my remarks. As I have said previously, time and time again, I would rather be very succinct and to the point, and this bill enjoys my 100% support. Thank you.
Thank you very much, Honorable Deputy Speaker. And now for the Honorable Member, Mr. Minister of Natural Resources, Mr. Vikram Bharat.
Thank you, Mr. Speaker. So fully support the Representation of the People Amendment Bill, Bill number 24 of 2022. Mr. Speaker, it is very strange that any opposition, as a matter of fact, will not support amendments that would strengthen the electoral process in a country. When the very opposition every single day for some of the very measures that are placed in these amendments tonight. Mr. Speaker, every single amendment in this bill this evening is to strengthen the transparency, strengthen the fairness, strengthen the accountability, and ensure we have free and fair elections in Guyana. And if there is an opposition that is not prepared to read the bill and to debate it tonight, then we are in a sorry state as a country. Mr. Speaker, the opposition loves to speak about government using taxpayers' dollars. Mr. Speaker, if I may remind them and let the people of Guyana know that the very taxpayers' dollars are paying the opposition MPs as well. They are receiving taxpayers' dollars. They are enjoying unlimited duty-free concessions similar to us on this side of the government house. They are receiving similar benefits as member of parliaments similar to us on this side of the house. So it is their duty to the people of Guyana to ensure that they come to this house prepared to debate such an important bill. Such an important bill, Mr. Speaker. So it is a very sad state and a sorry state when you have an opposition that is not willing and prepared to debate on such an important bill. But to use the easy part and said, let us take it to a special select committee. Miss, Mr. Speaker, I've been in the National Assembly since October 2016, when this very AP and new AFC was in government. And I have seen them taking a number of bills to the Special Select Committee that are probably still somewhere in the Special Select Committee. We have never seen the daylight of some of those bills that they themselves took to the Special Select Committee. Mr. Speaker, it is just a ploy to delay the process. It is just a ploy to frustrate the work of the government. It is just a ploy to delay the local government elections 2023, which will obviously embarrass the opposition. Already, there are issues among themselves. So that is why they were not participating in the consultations that we had. Instead, they were busy dealing with divorces. The AFC divorcing APNU on the 31st of December. They're busy fighting who should be opposition leader and who should not be. They're busy rigging their own internal elections, as one member of parliament who unfortunately is not here for obvious wrongdoing commented in the public that their internal rigging. So, Mr. Speaker, how can you trust an opposition where their own internal issues with election, they're rigging their own internal elections? How can they safeguard a national election? Mr. Speaker, 2020 is being used or being mentioned so casually, as if, it was no big thing. Mr. Speaker, that was an embarrassment to the people of this country. It was an embarrassment to this country as a whole, where many of their members were sanctioned. Many of their members, unfortunately, lost their visas as well, too. But yet they come to the assembly and they behave as though 2020 was nothing where we should talk about, that we should just move past that. Mr. Speaker, we are probably one of the only countries in the world where we had an election on the 2nd of March 2020, and 5 months after, then we were able to swear in the next president. We had multiple court cases that were basically baseless. We had GCOM officials who compromised their position and their integrity to undermine the electoral process and democracy. And yet, we speak of 2020 as if nothing really happened. 2020 and the AP and AFC disgraced our country. They brought shame to the people of this country. So, Mr. Speaker, as I mentioned, this bill is necessary. This bill is necessary regardless. The amendment to this bill is necessary regardless that we have a very strong electoral system in our country. Regardless that we have a strong electoral system in our country. And we heard from the member that spoke from the opposition benches before the deputy speaker about the list. Mr. Speaker, let us remind them that this is the very list that they claim to want the 2015 elections with. But when they won in 2015, the list was good. The list was clean. The list was perfect. But when they lost in 2020, oh, it is a bloated list. The list is padded. Dead people voted. And all sorts of excuses we're hearing from them today. But it is the very list. It is the very list that they won the election in 2015 with, that we contested the 2020 election. Now we hear about election petition, we hear about key court cases, we hear about bloated lists, we hear that the PVP is not interested in biometrics. The PVP have never said that. The People's Progressive Party of Civic have never said that we are against biometrics. What we have said is that it must be used to complement the existing system that exists right now. It should not replace the existing system, but it could be used to complement the system, to put further safeguards to our electoral process and the verification of voters on election day. Mr. Speaker, it was mentioned that we only speak of 2020, but maybe we should go beyond sometimes. We go back. Mr. Ramjitan said that Guyana started in 2015. But we know what happened in the past post-independence. We know what happened post-independence. 1968 elections rigged. 1973 elections rigged. 1998 elections rigged. 1985 elections rigged by the PNC. Imagine in 1973, the PNC claimed that they won 70.1% of the votes. In 1980, 77.66% of the votes. In 1985, the PNC claimed that they won 78.4% of the votes. Imagine that, Mr. Speaker. Imagine that, Mr. Speaker. And then they come to this house and talk about democracy. And talk about democracy and how our democracy is being derailed. But, Mr. Speaker, we witnessed the biggest rigging ever in this hemisphere during those periods. And then when we finally got a free and fair election in 1992, the PNC moved from 78.24% to about 45%. To about 45%. From 1985 to 1992. Mr. Speaker, as I mentioned, we have a strong electoral system in Guyana. But we need to improve as time moves on. We need to ensure that people don't abuse, as the Attorney General said, abuse their discretion, compromise their integrity. And that is what we saw in 2020. So these amendments seek to address those issues, seek to address the abuse of authority, abuse of their office, abuse of their power, and abuse of the discretion that is given to them. And to ensure that we legislate it, and people must follow the legislation and the laws, and ensure that there are strong penalties. It is very disheartening to hear an opposition member coming to this house, and the only recommendation or the only issue, relevant issue she could speak on was penalties are too tough. This is wrongdoing we are talking about, Mr. Speaker. You are rigging an election. It is fair enough for you to be fined $10 million and imprisoned for 10 years in jail. You're snatching the rights of every single Guyanese in this country. You're taking away our democratic right. You deserve even more than 10 years. Maybe the Attorney General was a bit easy or flexible. Mr. Speaker, there are a number of infractions, a number of inconsistency and abuse and compromise that we would have witnessed over the last few elections. Hence, our position today of bringing these amendments to the House. And one such infraction, I'll go through a few, Mr. Speaker. One deals with tender ballots. Tender ballots. Mr. Speaker, for the Guyanese people who are looking at this live broadcast, there are ordinary ballots and there are tendered ballots. Instances, right on the East Bank, where I worked in 2011, where a presiding officer issued 19 tendered ballots to voters who properly identify themselves, who are eligible to vote, who are on the list, but yet they were given tendered ballots. And Mr. Speaker, we know that the law states that tendered ballots is basically an appeasing ballot paper. It is only used when somebody comes to the polling station and they claim that they didn't vote, but their indication, and it is verified by the presiding officer, but that they would have voted. But because they're behaving unruly and disorderly, a tendered ballot is issued to appease them, but it is not counted. It is not counted. So because of that, 19 voters in Horstellian in 2011 lost their right to choose a political party to govern this country, even though they did nothing wrong. Even though they did nothing wrong. Mr. Speaker, it might sound very simple, but this amendment, one of the amendments listed here, is to correct this injustice that was done to the electors in Horstelling and many other areas across the country. Across the country. And every single election, if you add or total up the amount of tendered ballots that are issued to legitimate voters, it is probably in the thousands, Mr. Speaker. It's probably in the thousands. Mr. Speaker, moving on. We had similar instances in many polling stations where presiding officers issue ballot papers to voters without stamping it, without stamping the ballot paper. Mr. Speaker, based on the counting procedure and our laws, once a ballot paper is not stamped, then it is not valid. It cannot be counted. So, Mr. Speaker, we are correcting all these wrongs that has been part of the electoral process over a number of years. Another such infraction, Mr. Speaker, and which we are amending here, is misinformation given to voters by GCOM staff. And in some time, I think was 2006 or 2001, when they introduced what we call information officers. These are officers, 2011, sorry. These are information officers who sit at the gate or the entrance of a polling place. A polling place will carry more than one polling stations. And they will misinform, in some cases, willfully misinforming voters as to where they can vote and that their names are not listed on that particular list. There is a penalty for that, Mr. Speaker, because that is taking away the rights of people. And we know that once people are frustrated, and that is the purpose of doing that. Once people are frustrated, they don't go to a polling station, but they return home. And a vote is lost. Mr. Speaker, the issue of lists being given to polling counting agents on the morning of election. And this has been a big issue, and we have recognized this, and we have seen this during the recount, where we sat in this very building for 33 days to recount every single ballot cast in this country. And yet, the opposition mentioned 2020 as if it was nothing to worry about. Mr. Speaker, there were many instances where polling agents were given the list, and we know that they're normally giving the OLE the list of proxies, the list of discipline services members who would have to vote. Those lists are given to the polling counting agent on the morning of election. And in most instances, at the close of poll, the presiding officer will tell the polling agents that they will have to collect back the list. We are changing that. It should not be based on the discretion. But we are amending it here to say that the lists given to the polling counting agents must be kept by the polling counting agents. And mind you, Mr. Speaker, that every single party will have a polling counting agent at every single polling station, depending on their ability to do that. So it is not favored or it is not designed to benefit any particular political party. More so, it is not designed to benefit the People's Progressive Party. It is designed to ensure that there is fairness among all the parties and that all the polling agents representing all the different parties are allowed to retain and keep their lists so that it becomes the property of their party in case of any disputes after that. Mr. Speaker, the list of proxies. The list of proxies, and this is very critical because this is one avenue that was used in those years of rig elections. It was abused in those years of rig election, where people were forced to sign proxy lists to give up their right to vote to the next person. So what we are doing, attempting to do here, Mr. Speaker, is to ensure that we put it into the law. To state that the list of proxies must be posted up on the polling station, outside of the polling station, sorry, before election day. So that if there is any objection, it can be taken into account. Mr. Speaker, how can this be an amendment that will work against anyone who want a free and fair process? How can an amendment like this favor one political party only? It is amendments that will bring fairness to the process. It is amendment that will bring fairness and transparency and ensure that there's a level playing field for all political parties, and not only the People's Progressive Party. Mr. Speaker, if we may, the Honorable Attorney General spoke on the tabulation, but if I may go a little beyond that, as to recount, requesting a recount. And we can recall that in 2015, when our counting agent in Georgetown, the Honorable Charles Ramson, as the counting agent, requested a recount, but we couldn't find the officer. We couldn't find the officer before 12 o'clock of the following day to submit that letter requesting a recount, because the officer obviously went into hiding. So we are changing that now, Mr. Speaker. We are changing it that if we cannot find the RO for some reason or the other, or in some cases, the supernumerary returning officers, in the case of Region 3, 6, and 4, that the letter of recount can be served to the chairman as well as the CEO before 12 o'clock of the following day. And that is fair. What is wrong with that? What is unfair about that? What in that is giving the advantage to the People's Progressive Party? It applies to the opposition too. They can do the same. They can also serve a recount letter request to the chairman or to the CEO. So there is nothing in this, Mr. Speaker, as the opposition want to see, that is giving advantage to the People's Progressive Party. Because we have heard a lot about that. We have heard a lot that the People's Progressive Party is amending the Representation of People Act to favor them and to ensure that they stay in power. Mr. Speaker, we will stay in power because of our track record, because of the development that is taking place, because Guyana is the fastest growing economy in the world, because we are having new revenue stream every single day, the latest one being the sale of our carbon credits. So, Mr. Speaker, the opposition is obviously running scared, and they know that the writing is on the wall, that they will remain in the opposition benches for a number of years. So they're trying to clutch at every single straw. They're trying to clutch at every single straw, bringing out 2 or 3, 5, 6 persons to pick a GCOM every single day about bloated lists. The member said that we might have a list that is bigger than the population of Guyana. Mr. Speaker, if you look at some of the Caribbean islands, it is a common trend. It is a common trend in small populated countries where there's high migration rate, where people travel to work in different countries. But it is their democratic right to stay on the voters list once they're Guyanese. That is their right. We cannot take that away from them. That is their entitlement as the Guyanese. And as the Attorney General mentioned, they could live where they want to live. But because they're Guyanese, they're entitled to be registered and come home to vote. The APNU AFC is trying to take that away from Guyanese. That is undemocratic. That is undemocratic. So, Mr. Speaker, they're trying to clutch at every single straw. We made it clear on the biometrics issue. We heard tonight that the PUP is against that. We have never said that. We said that it must be used or it can be used to complement the existing system and to give more strength and robustness to the electoral process or the verification process. So, Mr. Speaker, there are many other infractions which we would have looked at that people obviously have used their position, the office, and the authority to abuse and to favor political parties that they are aligned to. And we have seen that in 2020. We have seen a CEO trying to disenfranchise almost 180,000 voters in this country. And yet we talk about 2020 as if it was nothing. But we had a CEO who was trying to say that 180 something thousand votes is not valid. And by what means? What was the criteria used? Only he knows. And the people who you were trying to put into office or to keep into office. Mr. Speaker, in the past, we have always heard this complaint from our polling agents that one, the presiding officer don't want to give them a statement of poll. That is illegal. And we have enforced it in this amendment here, Mr. Speaker, that every single polling counting agent must be given a signed, correct copy of the statement of poll. A signed, correct copy of the statement of poll. And it is an offense, there is a fine, and there is jail time to it, Mr. Speaker. Another complaint that we've heard many times is the GCOM officers tell that we don't have space in our vehicle for you to accompany the ballot box. And it is based on their discretion how much they can take, how much portions they can take, and who they want to take. We are seeking to change that in this amendment to say that it must be accommodated, if not in the vehicle where the ballot box is being transported, but maybe another vehicle accompanying them to ensure that it is safely delivered to the RO office or the supernumerary RO office in some regions. And what is wrong with that? It is not about the PUP agent alone. It is about all the polling agents representing all the different political parties. So these amendments, Mr. Speaker, is about bringing further fairness to the process. Is ensuring that we have an electoral process that is root-proof, because we have seen in 2020, even though we have a strong electoral system, an electoral system of verification, of identifying voters, of voting, counting, we have seen where people use their discretion or abuse their discretion to favor political parties. And that is what we are seeking to change in these amendments by taking those out. Mr. Speaker, I want to wrap up because I know maybe my time is going. I want to wrap up on the issue of consultation. There have been so many consultations held on ROPA. ROPA has been in the public domain for almost a year or maybe over a year, Mr. Speaker, where every single Guyanese, every single organization in and out of Guyana had an opportunity to make their presentation, to make their submissions, to make their contributions. And I have personally seen many submissions from a lot of organizations in Guyana. I've personally seen that, but none from the opposition. none from the opposition that's being paid with taxpayers' money, that enjoy the same benefits as our MPs over here, because there is no interest. But yet they come to the National Assembly and say, Senator Special Select Committee, without a single recommendation, without speaking on a single issue, without saying that, you know what, we support splitting Region 4 into 4 subdivision because it would help with the transparency and the efficiency of the process of tabulation, counting votes and tabulation. We have not heard that. We have not heard them come in and say, you know what, it is a good thing that we are reducing the number of voters per polling station to 400, because we believe that 400 persons can adequately vote at the polling station without any interruption. And 500 is too much, or 600 is too much. We have not heard, oh, it's good that polling stations are within the districts or close proximity to the people who are voting. We have not heard a single comment on the amendments that are being made in the Representation of People Act this evening, Mr. Speaker. But yet all we heard is about Senator Select Committee. We heard about how the context is charandas, the context is blackout, the context is bad infrastructure. I don't know, Mr. Speaker, how the context to the amendments here can be about those things. So, Mr. Speaker, it shows that we have an opposition that obviously don't value democracy. They don't value the rights of our people, and they're not willing, or they're not maybe not able to represent their constituency. And yes, the honorable member is right. They have a large constituency. The last elections, what, 216,000 Guyanese voted for the opposition. The figures are there, it's public. And we respect that. As a matter of fact, we love the 216 voters. We're trying to win them over right now, with much success too. So we are representing them. We are representing all of Guyana. We're not only representing the people who voted for the People's Progressive Party. And these changes here are being made to safeguard the rights of every single Guyanese. Every single Guyanese, regardless of which political party you support. Because every single Guyanese would like to know that their vote is secured, that it's counted, and their rights are protected when it's being tabulated or declared at the end of the election. So these amendments, Mr. Speaker, is a representation of the will of the people. It is a representation of good governance. It is a representation of true democracy. And as a government, creating a new modern Guyana, we will continue to make amendments to strengthen every single process, including our electoral laws. So, Mr. Speaker, I wish to fully support the Representation of People Amendment Bill 2022 and for successful passage in this House this evening. Thank you.
Thank you very much, Honorable Minister of Natural Resources. Now call on the Honorable Rising Ford SC to make this contribution.
Thank you, Mr. Speaker. Mr. Speaker, having listened to the Honorable Minister Bharat and listened to the Attorney General speak before, one might feel that the motivations for this bill, or that the reality or the purpose for which this bill was brought to this House, would have been actuated by the best of motives. Regrettably, Mr. Speaker, we all too well know that the political context that brought this bill is one in which the People's Progressive Party seeks to put in place a mechanism and a regime that is self-serving. Mr. Speaker, it came out very clearly in the repeated comments made by Honorable Member Bharat. For most of his presentation, he made bare to the public and to the citizens of this country that this bill was motivated by what they were told, we were told, being the People's Progressive Party, and the measures that they wanted to put in place in terms of their subjective understanding, of their subjective reality as to what is necessary to change the system. Mr. Speaker, as in any system, those who would have emerged victorious, whether by plunder, whether by fraud, whether by deceit, but takes governmental control, will obviously seek to implement a system that supports them. But, Mr. Speaker, it cannot be denied, that a number of areas of importance for the people of this country that the People's Progressive Party this evening wants to speak so much about are not captured in this bill. And why, Mr. Speaker, it's not captured in the bill? Because obviously, listening to what Honorable Minister Barrett said, it would not have been the things that it would have been heard or would have been told to them. For example, Mr. Speaker, the recount period revealed numerous and hundreds of instances of voter impersonation. It revealed, Mr. Speaker, hundreds of thousands of instances of multiple voting. It reveals hundreds or thousands of instances of substitute voting, and certainly indicated and revealed, Honorable Speaker, instances of persons who were deceased and recorded as having been voted. And also, Mr. Speaker, they reveal instances of persons who would not have been in the country at the time and would be recorded as voting. Mr. Speaker, the absence or the failure by the People's Progressive Party to address these issues leads one to come to the conclusion that they are comfortable with such a state of affairs, that they wish to benefit and continue to benefit politically from such a state of affairs. Mr. Speaker, isn't it amazing? Isn't it amazing that the Honorable Mr. Barrett will come to this House and in the course of his odd 20 minutes presentation, say at least twice that his party supports biometrics, but it must be used in complement to the existing system. We would have thought, Mr. Speaker, that such an important and remarkable discovery made by Minister Barra this evening would have formed an essential part of this bill. But, Mr. Speaker, it is easy to talk the talk. It is easy to talk the talk about biometrics, but to come up short in this bill on the issue of implementing such a system because it is absent from the bill altogether. Mr. Speaker, the first speaker on our side clearly pointed out the circumstances and the obvious rhetoric which was absent. Because if you want to come and you want to speak about electoral reform and you want to start not many years ago, you don't want to speak about a chief elections officer who almost ran off with an election years ago. You don't want to speak about a chairman of an election commission who publicly told the president or the incoming president that was good and later became an attorney general of the People's Progressive Party Civic. And you don't want to speak about a prime minister who sat on a seat that he's not entitled to. You don't want to speak about the chief elections officer coming up with a different electoral system to calculate ballots. You certainly want to keep the issues purely in a context of a political divide. And you're not coming to the table with your hands clean. Mr. Speaker, the greatest irony tonight, is that such a bill of such importance would have been brought to this House by the Honorable Attorney General, who himself, in the course of these electoral matters, himself mention was made of his participation one way or another in relation to ID cards. Mr. Speaker, that is probably among some of the greatest ironies that affect the preliminary matters in relation to this bill. But Mr. Speaker, I would like to address three areas of concern in relation to the bill. First, Mr. Speaker, the bill proceeds based on what the Honorable Attorney General said to deal with the issue of residency. And I understand and appreciate his efforts to remove residency. I understand it from a legal perspective, and I understand it more so from a political perspective. And certainly the question of residency will not operate to the benefit of the People's Progressive Party. But what I'm concerned about, Mr. Speaker, for example, and I will refer to the bills alternately, when we look at, for example, Clause 4 of the National Registration Amendment Bill, it seeks to replace, and even in the representation of the amendment bill, seek to replace the reference to residence with an application with an address or the date of the application. But certainly, Mr. Speaker, at 4D, the reference is made to the fact that on a successful verification of the address, the particulars of the first-time registrant has to be determined by the officials of the Guyana Elections Commission. Mr. Speaker, qualitatively, the issue of residency had historically formed part of our criteria for an assessment of the allocation or location of a member of the public as to where they would have voted. That would have been said by the Chief Justice in the Christopher Ram matter. That even though in her opinion, which we disagree with, but respectfully, even though she said that there's no issue of a residency requirement, residency was important in terms of allocating a person as to where they should vote. And she went on in her decision, it's right here, being objective, it's right here, to say that in those instances, it is where the person lives. Now, Mr. Speaker, what we have here is the fact that the learned Chief Justice, in her decision, made that position clear. And even though up to now it has not been vocalized by the Attorney General, clearly in his mind or in the mind of his government was the fact as to how could I deal with that issue in view of the statement of the Chief Justice. But to remove residency requirement, Mr. Speaker, altogether for resident Guyanese and to put in place the phrase with a registered address across the board, Mr. Speaker, for all Guyanese persons who are seeking to be registered, whether they're resident or not, in my respectful opinion and in my party's position this evening, Mr. Speaker, is that it brings into question or brings into the legislation a very important area now that is unclear, because now they must produce proof of address. There's no recognition in terms of what is the assessment that the Guyana Elections Commission is to engage in the verification of the address. So, Mr. Speaker, we believe that that is an area that ought to be fixed and addressed in the bill. Mr. Speaker, the issue of the new systems of Region 3, 4, and 6 and its subdivision, whilst it may be motivated, according to the other side, by their understanding of what is in the best interest of the Guyanese people, Mr. Speaker, these represent only 3 of 10 administrative regions. And automatically, Mr. Speaker, this will be the first time that our electoral system will have differences in the manner in which votes are counted and tabulated throughout the system. We believe, Mr. Speaker, and I'm happy to hear the Attorney General says that he agrees that that is the intent. Mr. Speaker, we believe that this opens the system clearly on the face of the legislation for the creation of an inequitable system that is partially structured in a particular way in relation to those regions. While the same concerns that existed or probably would have motivated this effort remains extant for the other remaining regions. Mr. Speaker, the Attorney General and I would like to commend the staff of the Attorney General Chambers for the obviously tremendous work that they would have undertaken in the attempt to rationalize and to put in place different aspects of this act into the respective areas. But I believe, Mr. Speaker, there's one significant area of the attempt which requires some review, and that is Section 33A 6, 33A6 of the Representation of the People's Act. Mr. Speaker, without the obvious change in 33A6, which previously I believe was Section 56 of the Election Laws Amendment Act, which has now been changed to deal with the question of a registered address instead of residency. Mr. Speaker, this provision came into existence in Section 56 originally of the Election Laws Amendment Act. And it's important to note, Mr. Speaker, that at no time in relation to local government elections was this provision applied in relation to local government elections to the extraction of a list. In 2016 and 2018, the local government election laws was used, and in relation to the 1994 elections, the PPP government passed a specific amendment to deal with the use of the 1992, I believe, electoral list. So, Mr. Speaker, this is the first time that this provision is being used in a local government election. And what it does, Mr. Speaker, whilst maintaining in the Local Government Amendment Act or the Local Government Elections Act specific provisions dealing with the manner of preparation of a register of voters, deals with the manner in which a register of voters is to be produced, and more importantly, Mr. Speaker, the Local Authority Elections Act deals specifically with the standards or the qualifying criteria for electing those elections. In this one, in 33A6, it specifically says that the Commission, if it so directs, notwithstanding anything set out in any other law, allows you to use the electoral laws dealing with the election of the National Assembly. So, Mr. Speaker, what Section 33A6 in its present format does is to give the Elections Commission, and I respectfully believe, Mr. Speaker, and my party feels so too, that it gives the Commission the option of determining what would be the criteria. Because, Mr. Speaker, under 33A6, the persons who are to vote would be the persons with a registered address in a local democratic organ. But if you look at Section 10 and 8 of the Local Authorities Election Act, you would see, Mr. Speaker, it is a person who's ordinarily resident. So even though in the current cycle of local government elections, the list would have already been extracted without reference to persons with a registered address, it would have been extracted on the basis of persons who would have simply been resident in the local authority area. And the definition, Mr. Speaker, of resident under this act and ordinarily resident under the Local Authority Elections Act are two completely different provisions. Mr. Speaker, when you actually look at the introductory language in the Election Laws Amendment Act, it says that it was to pass laws in relation to the National Assembly. This section falls into now completely into the Representations of the People's Act, which says specifically that it's to pass laws for the elections to the National Assembly. But we have this anomalous section, I believe, lying here in Section 33E6. Mr. Speaker, we believe that this bill cannot be supported by the opposition, and we do not offer our support to this bill. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member, Mr. Ford. And now for the Honorable Member and Minister of Public Service, Ms. Sonia Pearl.
Mr. Speaker, I stand in full support of my colleague, the Attorney General, in bringing Bill